Good morning, everyone, and welcome to another Sharp Minds. My name is David Leach, and I'm an associate in the employment team here. And we've just got a couple of more people who are joining. But today, I'm going to talk about pension disputes, the IDRP process, and the pensions ombudsman. As I start, the main element I'm going to be looking from is mostly local government, so the LGPS, and defined benefit schemes rather than defined contribution schemes. So if you hear me saying DB throughout this, I'm referring to defined benefit schemes rather than DC schemes. Obviously, if people have any questions throughout, there is the Q&A and the chat function, and I'll try and keep an eye on those and answer questions as I can as we go through. The slides and the video will be circulated as soon as possible post this session, so people will have a copy of those. So today, what are we going to look at? Well, effectively, an overview of what is a pension dispute, who's likely to be involved, where do these sorts of disputes come from, and how are they dealt with? So really, what is a pension dispute? Well, it's when a member, and a member is an open term here, has an issue with their pension scheme. And then they go through the IDRP process, so the internal dispute resolution procedure. They also can go to the pensions ombudsman or the financial ombudsman complaint. There is also court proceedings, which we're not really going to talk about much here, but that's more in relation to the trustee management of a scheme, so professional negligence claims in relation to someone's management of the scheme, and again proceedings concerning the administration of a trust, because ultimately a pension scheme is a trust in all but name. So obviously if there's mismanagement of a trust, then there's court proceedings that can be brought. And then also there is the pensions regulator themselves who can bring proceedings against trustees and pensions schemes themselves. But we're mainly going to be talking about the IDRP and the pensions ombudsman in this. So member disputes. Well, obviously this is where you get a member gripe. And then there's a lot of administrative work involved. And then it kind of splits into two processes. So firstly, you've got the IDRP, which will move on to the pensions ombudsman and ultimately court afterwards if people aren't happy with the PO outcome. Or there's the early resolution service. So for those who are involved in employment disputes, you'll have heard of ACAS. The ERS is effectively the pensions ombudsman's version of that, but only in the sense of it's there to try and informally resolve pension issues as quickly and early as possible without going to the pensions ombudsman himself to make a determination. It is not a requirement to engage with them, and lots of people have found that the ERS is actually sometimes not helpful. They don't really understand pensions. Pensions in themselves are ineffably complex, especially as each pension scheme can be very complex on its own rules in and of itself. So they're not really that knowledgeable. So can be fighting the members' side a bit too much and not listening. But you're not required to use the ERS. It's not a mandatory procedure as part of the pensions ombudsman's complaint. But ultimately, if you feel you can bring the issue to an end via the ERS, then use it. It can have some benefits. And one thing to look out for if you ever get a letter from the pensions ombudsman is check who it's come from. So if it's actually from an adjudicator or an investigator, then that is a pensions ombudsman's complaint and you need to be dealing with it. And I'll talk about that further later. But if it's from the ERS and they're putting in timescales, they're putting in demands, these are effectively empty threats, but still deal with it if you can. It's not something you can then put on the back burner, but just make sure that you're keeping an eye out on them as well. So the first port of call really is the IDRP, and that is the pension scheme's own internal dispute process. This was set up in the Pensions Act in 1995, which required people to have IDRPs. And then there were some further changes in 2008 just to add some flexibility to the process. So it can be a one-stage or a two-stage process. It is entirely up to the pension scheme. I know a lot of local authorities now generally have a two-stage process. So the first stage will be either the pensions officer or someone within the pension service at the administrating authority reviewing a decision that's been made, potentially usually with advice from legal or from others if needs be, and then the decision is made. And then obviously if that's appealed, it goes to stage two, which is usually someone higher up or potentially close to trustees, obviously, which is difficult in the LGPS because it's quite a large scheme and the trustees are a bit more anonymous than they would be in a smaller scheme. If you have a one-stage process, then usually it is the trustees or someone at the very top making that first decision and only review decision. Now, advantages of the stage one is they can be a lot quicker. There's less cost because you're only doing a one-person stage. But stage two or two-stage processes can implement lessons learned faster. So, the stage one has an outcome, it's dealt with and moved on. And obviously, it's a lot easier to work with a larger pension team, certainly when you've got local authorities making decisions on behalf of large-scale pensions, then it can be a lot more easier to do that. Who can complain? Now, this is quite a large list of people. So obviously, the first one is members, and this is either active or deferred members or pensionable members under the scheme, or anyone getting the benefits. So spouse, children, or anyone who should have got benefits. So we're looking at things like death and service benefits there, someone who should have got that benefit and didn't. And also anyone who thinks they are one of these categories. So that is the bit where it's very, very large in who can bring a complaint. Is that last category of who thinks they might be one of these sorts of people. And well, what can they complain about? On the next slide is common complaints. So transfers, whether they're historical or recent, so transfers across schemes, transfers that employees have asked you to make. There was one a while back where loads of people were effectively absorbed into a pension scam, and people were asking to transfer their pots out of the LGPS into something else, and saying, if I don't do it within the next 15 days, I'm going to lose out loads of benefits. And doing this, local authorities were a bit slow, and they lost benefits. So there's things like that. Administration errors, so that can be anything really, and that's usually quite the common one. Death benefits, who got the benefit and why. Ill health retirement. Now, I know that can be quite a common issue as to what level of ill health retirement someone's entitled to. And then misstatements. So you get sent your pension statement every year, whether you're an active or deferred member, tells you what you've accrued, and there's something incorrect in that. Or overpayments. Now, this is an odd one. No one really complains about an overpayment, because why would most people complain about an overpayment? But obviously, this is a dispute in relation to the administration of a pension scheme. If someone has obviously been given too much, and how does an authority deal with clawing that back? So really, what do you do when you get a complaint? Well, obviously, once you get it in, read it fully, understand what the complaint is, and also then really check your IDRP process. What are your time limits? Do you have a certain number of days to respond in? Are you going to be able to meet that time frame? If you can't meet that time frame, then explain to the member very quickly why you can't meet the time frame, and extend it as necessary. What is the issue that they're raising? And looking at the trust deed and rules. So in the LGPS, obviously, that's going to be the pension regulations more than anything else. But ultimately, look at what the rules say that should have been done or was done, and why. And did the member know about these rules? So an example I've had in the past was something in the fire pension scheme, what's called the commutation of someone's pension. So a member had left, they had retired, and then returned to employment. And the rules at the time were, if they return to their employment and their salary is greater or the same as their exit salary, their pension is paused and they are paid the salary instead. So they obviously stopped getting a mixture of both pension and salary. This member complained, saying they weren't made aware of that, and it all went to the pensions ombudsman, who then asked for the decision to be remade on the commutation, basically saying there didn't seem to be enough information provided to the member that they knew about this, and they potentially would have not rejoined employment or have taken employment at a lower value. But all that the ombudsman asked in that situation was for the decision maker or another decision maker to retake the decision. And then again, in your IDRP process, who are the decision makers? It should set it out. Are they actually available to make a decision? People are busy, they have other jobs. Pensions can be overrun by valuations, or they can be doing 2P transfers where they need to be dealing with that. So there's always a lot of things that a pensions team will be dealing with on a day-to-day basis. So if they are required to make a decision, are they actually going to be available to make a decision? And again, if not, explain to the member why. Sorry. Explain to the member why, and obviously setting that out as quickly as possible. If you need to delay anything, it's explained to the member clearly, because obviously if it's not, they're going to bring that to the pensions ombudsman at some point if they continue to be unhappy. Then obviously the next stage is the pensions ombudsman, and that is an individual person. Obviously it is an organisation. Sorry. It is an organisation, but ultimately the pensions ombudsman is an individual person who makes determinations. Now, at the moment, there is so many bits of work for them. They've actually got a deputy pensions ombudsman, as there are 2 people making decisions, but at the moment it's still effectively one gentleman who's making it. Now, on the screen is kind of their own views of what they are, and then also the court's views on the pensions ombudsman. And as you can see from the quotes, they are wildly different in how people view the pensions ombudsman and the work that they do. And I think most of us who have had some involvement with the pensions ombudsman in the past more likely will default to the court's view than the pensions ombudsman's view in how things are dealt with. But they are an important thing, and I think probably out of all of the ombudsmans that exist, they are the one with the widest ranging powers in what they can do, and also distress and inconvenience money that they can hand out, which I will discuss shortly. But they very much have a wide remit when it comes to making determinations and decisions. So what really is pension ombudsman made up from? There's the early resolution service, which I talked about earlier. There is the adjudication team. Now, that is the big team of people who are supporting the ombudsman. They are the people that generally do the investigations, make recommendations, I should say, not determinations, and generally try and solve problems before they actually get to the ombudsman himself. And then obviously there is the ombudsman who makes the determinations if they get to that sort of point. So what can the pensions ombudsman actually deal with? So this is kind of their jurisdiction and who they're involved with and what they kind of look at. So the main thing is disputes of fact or law in regards to pension administration, actual potential beneficiaries of potential administration. They can deal with the administrators themselves, whether that's the trustee or the administrating group, so such as administrating authority, maladministration, and sustained injustice in relation to pensions. That's kind of the overarching things of what they will look at. And again, who can complain? It's the same list as we had earlier in regards to who they will listen to if bringing a complaint towards them after the process. Now, quickly just touching on maladministration. This really is, a public law sort of issue, and it's when you're administrating the scheme, and there's obvious bias, inattention, delay, incompetence. Any decisions seem really perverse or just arbitrary. Now, obviously, this is usually seen in a lot smaller schemes with a lot of smaller numbers of trustees, and certainly less competent trustees. With the LGPS, obviously, you've got, and the civil schemes in general, quite a wide remit of competent and very competent pensions officers in those local authorities, and also the administrators of the schemes in general. The smaller schemes now, you can see it, as most schemes are required to have professional trustees involved to make sure the scheme is actually administered properly. These sorts of things are less so seen nowadays, but I'd probably say inattention is probably the biggest one of people. It goes on the back burner, and arbitrary decisions sometimes, and that seems to be around death in service benefits. It's the spouse, that goes to them without really digging into who is entitled under the rules to actually inherit a death in service benefit, because ultimately, whilst there is people's elections, we've all probably filled in a form saying, who do I want my pension to go to, and in what form when I pass away. Ultimately, it is the trustees who make that decision, and their arbitrary decisions can take place there. So like I said, on the screen there, it's generally focused more on procedural matters than anything substantive. I mean, probably the big ones are raiding pension pots or employers not contributing correctly into the pension pots, probably the closest you have to a maladministration on that side, and the trustees not keeping an eye on top of it and realizing that the employer isn't paying in and not doing anything about it. The pension ombudsman does have things that they can't look at, and if it falls into any one of these categories, the pension ombudsman will refuse to deal with the matter. So obviously the first one is the IDRP process has not finished. They haven't determined the answer yet. The pension ombudsman will say, please come back once that's been done, and if necessary, they will then look at it. Someone has issued court or some form of tribunal proceedings against the pension, the ombudsman won't touch it. And also if another ombudsman, specifically generally the financial ombudsman, has also picked up the complaint and is dealing with it, they don't then get involved, and unlikely will get involved at all once the ombudsman has made a determination. And also if a court or tribunal make a determination, they will unlikely get involved. The only one that they will do is obviously the IDRP. They are the next step after that process if the person is not happy. Quickly on time limits to bring a complaint to the ombudsman, it's 3 years from the issue arising or when someone ought to have known the issue arose. And the IDRP is carved out from that. So the IDRP takes 2 years. It's 3 years from the end of or the issue, ignoring the 2 years the IDRP process took place, and then the remaining time left over for that person. The ombudsman can also grant an extension to time if they feel it's necessary, and it's not been reasonable, but again, slightly rare, mostly because 3 years is quite a long time to actually bring a complaint to the ombudsman, that they rarely do so. So keeping an eye out of delaying through the IDRP process isn't actually a delay. Someone can still go to the ombudsman even if it's been over 3 years, if you've taken an extremely long time to do the IDRP process, and probably expect an additional complaint on delay through the IDRP process into the ombudsman. So what can they do? So they really have quite a wide-ranging power, as you can see there. They can direct any person responsible for the management of a scheme, so that's the trustees or the management officers, to which the complaint relates, to take an action, refrain from taking action, or any such steps as the ombudsman tells you to do so. Now, mostly I'd say at this point, the ombudsman doesn't really direct people to take specific action. They don't like doing that. The usually specific action they ask is to reconsider the decision and make it again. And this is the main thing that they will do. Is I've not seen many ombudsman's decisions where they've actually pushed apart a decision and said this is what you should have done. So I think that the main thing here, and again I will touch on it later, is decisions aren't required to be written down. There is nowhere that you have to set out your consideration for making a decision. But on the other hand, I'd highly recommend it. The big thing that the ombudsman would do, I can't see any record of why you reached this decision. So how did you reach this decision? And if you can't explain it, the ombudsman's going to look, well, did you consider everything properly? And there go, can you make the decision again? So the main thing when making any decision is to take all relevant factors into consideration and ignore all irrelevant factors when making your decision. So the only way you can really evidence that is if you've written it down and when a decision has been made, and that's always going to be your best decision and defense when you're ever dealing with the ombudsman. And also at the bottom there, it's talking about distress and inconvenience money. This is something that the ombudsman I have seen just seems to hand out effectively like sweets at Halloween. It ranges from £500 up to £1,000, if not more. And it seems to be very obscure what their rationale behind it is. I've seen one where someone really didn't actually suffer any detriment, but still had a legitimate complaint to the ombudsman, and the ombudsman handed out £500 distress and inconvenience, when actually there had been no suffering from the member. Their pension was safe. They had been paid instead of having their pension. It's the fire one I was talking about earlier, and they were still handed out money. So I think it's almost in the sense of they just like handing it out. Obviously with nowadays and costs, it seems to be steadily increasing in the amount that they hand out. So it's something to try and avoid if you can. Obviously, it's at the end of a pensions ombudsman's decision that they will hand out that amount of money, and it is something you can make representations on when responding to a pensions ombudsman complaint, that the person hasn't really suffered distress and inconvenience. I think it's the same, the closest I can akin it to an employment law is injury to feelings. It's how distressed and inconvenienced they've been, or how injured are my feelings. The ombudsman kind of just does sometimes feel like they stick their finger in the air and go, well, I'll just hand out this today. So it is something just to be very aware of if you're at a pensions ombudsman complaint, that there's likely to be money handed out. Even if you then remake the decision, do it all properly, and still make the same decision, you'll be paying out some money, it seems like, for distress and inconvenience. So really, what is the process? The pension ombudsman can investigate anything they consider appropriate in relation to the administration or execution of a pension. It is free, and what it says there is no statement of case needed. So what this means here is that the ombudsman is not, like a court, bound by someone's pleadings. The ombudsman can look behind the complaint and see if actually the complainant has said what they need to say. Is there more here? If the complainant says they didn't transfer something on time, is that the only thing that they're really complaining about? So be very, very careful. The complaint could suddenly grow on you when it goes to the ombudsman, and you can't tell the ombudsman, well, they only complained about A, so you shouldn't be investigating B, C, and D. The ombudsman can investigate A to Z and more if it chooses to, if it finds a reason to do so. So be very careful when looking at a complaint that's coming in, that it could suddenly expand, and the ombudsman has and will expand where necessary. So the investigator, once the complaint will be received, will write to the administrating authority or to the trustees or whoever they need to, and an investigator will set out that you have 21 days to provide all necessary documents that they're asking for and a full response. Now, whilst that is obviously a strict time limit you should be following, the pension ombudsman is overloaded with complaints at the moment, and has been for a long, long time. So if you desperately do need time, write to them and say, please, can we have an extension of time, and why? And they will usually grant it. They want people to provide full answers. They don't want people rushing these sorts of things. They're not going to give you 6 months, but they will give you time to provide your response. And whilst there is no structure or format in providing your response to the ombudsman, it is recommended to, effectively as you can, do it like court-like pleadings. It is written advocacy. You're setting things out chronologically, decisions that have been made and the evidence as to why a decision has been made, and walk it through so the ombudsman can follow what you're doing. Be concise and being clear when you're explaining things to them, but effectively that is what you should do. So no answer will be the same, but the ones that I have done in the past have just been, unfortunately, exceptionally long letters with lots of documents attached to them, setting things out, and then ultimately at the end you set out your conclusion as to the complaint going forward, and also, if you feel like it, comments on the distress and inconvenience money that the ombudsman might want to award, and trying to reduce that as much as possible. So like it says there, they can proactively investigate. So again, things might change under you. Usually once the complaint is out there and then the investigator has looked at it, that's when you will really know what the full complaint is and you answer it. An adjudicator might provide an opinion. Now, it is an opinion on something. It is not binding on anyone. It is just their opinion. But if it goes to the ombudsman and they make a determination, then that is legally binding on the parties. You must follow it. Like I said, it's usually going to be remake the decision and a time frame to do it. So if you think that's going to be the answer, make sure you've got a decision maker available to remake the decision within the time frame. If you don't, obviously it's possible contempt actions against the against the ombudsman, and judgments are enforceable in the courts. Obviously, like with most things, if there is an appeal, it is on a point of law. So if you believe that the pensions ombudsman has made a mistake at law in their determination, you can appeal that to the courts, and the courts will then look at the decision. If you just don't like the decision, you can't appeal it. It's one of those scenarios. So be very, very careful as to how you do that. And obviously, if you have a decision against you, you need to act on it quickly. So just some figures really, and these are from 2022 to 2023. I don't have any latest figures at the moment, but as you can see, the majority of complaints to the Ombudsman are still dealt with at early assessment. So this is someone's made a complaint, an investigator looks at it really quickly and makes a recommendation or some form of, or just closes it down because it isn't actually a complaint. Now, also, this could be an awful lot of these things of someone's complained and they've gone, you need to go via your IDRP process first, come back later. So there's the whole remit of what that can be enclosed after initial assessment. The ERS, as much as I've already criticised it's a little bit too much, does have some help and has resolved things quite early on. And obviously, as you can see, opinions from investigators are very, very small, and determinations by the Pensions Ombudsman are even smaller. So, the Ombudsman doesn't make a lot of determinations, but still does make them. So obviously, you don't want to be in the 4.2%. You want to be hopefully not going anywhere near them, but obviously, hopefully earlier in trying to deal things. And obviously, that's really looking at your IDRP process, getting that as right as you can. I mean, it's the same if, we all say with employment, you can do the best decision possible and someone will still complain. So obviously we can't eliminate people going to the Ombudsman, but if your IDRP process is done on time and you're making reasonable decisions and you're evidencing this to members, a lot of members are very happy and then will walk away. Ultimately, it's the administration of the pension scheme is the first port of call. If there are issues there, then obviously they need support and help to get that rectified. So really, just to wrap up on this and tips for people, really, members have nothing to lose by going the IDRP process. So, it's free for them. It's the complaints. It's a bit like the ACAS system. People will raise issues, and a lot of them will be nonsense, but there might be some with substance in there. So when you are investigating that and you find out that a decision has been wrong, don't be afraid to change your views. If you need to make a change, please do so. It's better to admit if a mistake has been made and deal with it early than getting to the Pensions Ombudsman months later and still having to do the same thing and having spent a lot of time on it. There also might be tactics for settlement with the member. So, some things can't be undone, but can you do different things now and reach an agreement with them and settle with them? Again, it happens, it's rare, but it can work. Then, when you are writing to the Pensions Ombudsman, give a full response and the documents asked for, and be clear and concise in your responses. The best thing is, if almost say, like, if a child can understand what you're saying, the Ombudsman's going to understand what you're saying. Now, obviously, he is a very intelligent man. The Ombudsman service is very intelligent, but if it's clear and concise and very easy to follow, he can make a decision far quicker than needs to be, and hopefully can provide one in your favour. Now, I would also say don't put too much weight in past decisions. Obviously, every decision is published, so you can read them. But if you look at one and go, well, that's a decision he made yesterday, that's one he made yesterday. He can be a very different person today and tomorrow. There is no precedent setting. He will look at the facts in the case in front of him and make a decision. So don't expect any form of consistency. He's not required to be consistent. He's making a decision on the specific issue in front of him. So treat them with a little bit of suspicion if you are going to try and rely on them, unless you are looking at very large schemes and very large decisions in relation to schemes. Then don't put too much stock in them. And obviously, Pension Ombudsman decisions are public, so obviously there is the occasional adverse press in them. Very rare. I mean, the biggest one, it's not really a Pensions Ombudsman, but for those who work in the fire service, has been the McLeod decision and changes into that pension scheme. So obviously that is a very large pension issue that's been in the news a while back. And obviously, as people get older, people's view on pensions becomes far more forefront in their thinking, so they will look at it. So obviously that's been quite a relatively whistle-stop tour on an IDRP process in the Pensions Ombudsman Service. Like I said, there are court actions on top, but we haven't really looked at that in today's session. So if anyone has any questions, please either raise their hand, put them in chat, and I'll try and answer them. But mainly, thank you very much for listening. And our next Sharp Minds in November is going to be on data protection, and mainly looking at data protection and interactions with employment, so subject access requests, employees using FOI and EIR requests when actually they are using them for an employment purpose, and that will be covered by both ourselves and our member of our data protection team. So if you are interested, please keep an eye out for that. So Unless there's any other questions, I'd like to say thank you very much for attending and see you all in November.